I need to do know which cases. Good morning.
You just, yeah. Oh, okay. So we only needed that over. Okay. I'll check. Okay. We sit here for the security. I'm sorry. I didn't know what else to do. Y'all have a good day.
No, we just aren't checking.
This just happened. Say she.
Cedric Jackson.
Judge King. Boykin. Sorry, yeah.
Good morning, ladies and gentlemen.
Morning,
Good
Judge.
morning. Good morning, Judge.
Morning, Judge.
Okay, first up, I have Ms. LaShawn.
Good morning, Your
Oh.
Honor. I have Cedric Jackson, but I don't believe my prosecutor, who I think is Erica Moses. I don't think she's on the line yet.
That's okay, I don't have a court reporter yet either.
But other than that, it's going swimmingly well on a Monday.
Good morning, everyone. How you doing? That's what you got. I apologize for the wait, folks. We're just waiting on the court reporter.
Morning.
Morning.
Yeah.
Good morning.
Ready?
I am.
All right, folks, again, sorry for the delay. First up, Ms. LaShawn, who do you have?
Judge, I have Cedric Jackson. I'm not sure if my prosecutor is on the line or not.
Do you know who the prosecutor is?
I think it is, at least according to Odyssey, it should be Erica Moses. And I don't see her on the line. Ms. Narcessian is, so I don't know if she's standing in or not.
Hi, Judge. No, I'm not. I'm here on another case. I'm sorry. If it's Erica Moses, it's a child abuse.
Understood. No worries.
Okay, I'll come back to you. Here she comes now. Ms. Moses,
Yes, Your Honor.
ready on Jackson?
Yes, sir.
Okay, let's call.
Calling case number 2405-684201 because David Smith versus Cedric Jackson. Defendant is charged in count 1, criminal sexual conduct, first degree. Count 2, kidnapping. Count 3, unlawful imprisonment. Defendant has a habitual offender, third offense notice.
Appearances for the record, please.
Thank you, Your Honor. Erica Moses on behalf of the people, P78491.
And good morning, Your Honor. May it please this most honorable court. Kim Michon, Neighborhood Defender Services, P59167. On behalf of Mr. Jackson, who is in the Wayne County Jail, we would waive his appearance for these purposes.
Court will waive the defendant's presence. What's your pleasure?
We need a preliminary examination date, Judge, and I do need discovery in the matter.
I'll send to you. Today.
May 6th at 12 o'clock.
May 6th at 12 o'clock is perfect.
Can I have one moment, Judge? I'm sorry. Yes, sir.
That's a good date and time, Ms. Moses?
Yes, sir. That works. That works fine. Thank you, Judge.
May 6th at 12 o'clock. Make sure Ms. LaShawn gets all the discovery that she needs, okay?
Yes. Ms. Michon, may I sign your name to a protective order, the standard order?
Please and thank you.
Thanks, Judge.
And a lovely day, Judge.
Thank you, you too. Mr. Butchar, good morning.
Good morning, Your Honor. I have Miss Boykin.
All right, Ms. Boykin, we were contacted by the Wayne County Jail. They won't bring her before a camera today. Apparently, she's having some issues there.
Understood, Judge. I'm willing to waive her presence.
Okay.
Calling case number 2405-683901, people of the state of Michigan versus Shaquille Boykin, defendant is charged in count one, assault with intent to degrade bodily harm, less than murder or by strangulation. Count two, domestic violence. Count three, interfering with crime report. Defendant has a habitual offender or offense notice.
Appearances for the record, please.
Good morning, Your Honor. Shelley Drain for the people, P number 60249.
Daniel Batar on behalf of Ms. Boykin, Your Honor, P62191.
And what's your pleasure, sir?
Your Honor, could we set this for an exam, please?
It is May 6th at 11:45.
Judge, if you don't have anything earlier, I would ask you to do it on the 7th or the 9th. I could do the 7th at 11:30. I could do any time on the 9th.
Okay, so both of those are my homicide days. What about the 8th? I can do 10:15 on May 6th.
That's fine, Judge. 10:15 on May 6th.
All right, 10:15, May 6th. To be continued.
Thank you, Your Honor.
Thank you. Ms. Manarino.
Morning, Judge.
Good morning. How are you doing today?
I am well, and you?
Good. What do we have?
We have Mr. Dante Smith with Miss Lindsay, and it's a competency. We have a report from the Forensic Center, but I'm going to be asking for an independent to look at it at this point.
And Your Honor, I am going to, morning, Your Honor, Lisa Lindsay on behalf of the people of the state of Michigan. I am going to.
Well, let me call it since we're getting so formal here.
Calling case number 2205-940501, people of the state of Michigan versus Dante Smith, defendant is charged in count one, assault with intent to murder. Count two, animals killing, torture, 33. Count three and four, weapons, assault, and firearm. Defendant also has case number 2205-940801. Defendant is charged in count one, homicide, murder, first degree premeditated. Count two, weapons, assault, and firearm. Defendant also has case number 2205-940701. Defendant is charged in count one, homicide, murder, first degree premeditated. Count two, weapons, assault, and firearm. Defendant also has case number 2205-940801. Defendant is charged in count one, homicide, murder, first degree premeditated. Count two, weapons, stolen, firearm.
Appearances for the record, please.
Good morning, Your Honor, Lisa Lindsay on behalf of the people of the state of Michigan, P number 39570.
And good morning, Maria Manarino, P39531, on behalf of Mr. Dante Smith.
Oh, Eric, like, could I'm reading them out?
Yeah.
For purposes of this proceeding, Judge, I'd ask the court to waive his presence.
The court will waive the defendant's presence. My understanding is that we have a report back from the Forensic Center finding the defendant competent to stand trial.
That is correct, Your Honor.
I have received a copy of the report from Miss Lindsay, thank you. And at this point, Judge, I'm not prepared to stipulate to that report.
Well, Your Honor, I am going to stipulate I am moving to stipulate to the report, and as the court may or may not remember, initially when the defendant was, a report came back, the defendant was declared incompetent. I objected to the report, and Ms. Manarino argued to the court that the court could take the report over my objection. I see she's smiling, and the court did in fact take the report over my objection. And I would indicate to the court if it was her position initially that was the law, and she advocated to the court that was the law, that the court could in fact take the report over her objection, I will be asking the court to do the same. As I noticed that she indicated that she wishes to have an independent, but according to the Michigan Court Rule 6.125 dealing with mental competency hearings, the independent examination is a discretionary call on the court's part. And I'm going to read directly from the rule. On a showing of good cause by either party, the court may, not the court shall, the court may order an independent examination of the defendant relating to the issue of competency to stand trial. And then I'm going to refer the court to the commentary to Michigan Court Rule 6.125. And this can be found in the court's bench book. It says, because of a presumption that the Center for Forensic Psychiatry or other facility officially certified by the Department of Health will properly perform the function, good cause justifying an independent competency examination should arise only in exceptional cases. And then there are some unpublished cases dealing with that, saying that it has to be an exceptional reason to find good cause to order an independent. And in this case, Your Honor, I don't think that there's good cause. The defendant has been in the forensic center in excess of 6 months, and they have been working with him daily. They have been observing him daily. And I don't think there's good cause to order a independent evaluation, because all this person would be doing would be reading the report and opining without seeing on an everyday basis, whatever their opinion is. There is no good cause for independent evaluation. This case, the time to restore him to competency expires on May 2nd of this year. This case is old. He has been monitored every day. He's been getting treatment at the forensic center, and they have diligently been saying that they thought that they could restore him to competency before the end of the period. And for those reasons, Your Honor, I'm going to ask the court, not to order an independent. And if Ms. Manarino does not want to stipulate to the report and the court is not prepared to take the report over her objection, I would suggest that we schedule a hearing, and we can schedule a hearing one morning this week to get this case rolling.
Ms. Manarino, give me good cause.
Well, Judge, Mr. Smith, the forensic center has opined that he was incompetent. And, you know, and here we are literally on the eve of the expiration of the time period, and miraculously now he is competent. I understand he is being treated and medicated, and it could very well be that he is now competent. I just need my independent who has previously interviewed him and given his opinion. I just want him to have an opportunity to interview Mr. Smith and determine whether or not, in fact, he is competent. Quite frankly, I have not had an opportunity to meet with Mr. Smith since the report came out. I would like the opportunity to do that and determine whether or not I believe he can rationally assist me in his defense right now. So we're just asking for...
That would be cause if you had met with him and made that determination that he's not able to assist in his defense, then I would say you're on to something. But given that you haven't even met with him, how can you object to the forensic center's findings?
Because I'm not in a position to either accept or not accept. I mean, the court's aware I was gone all last week. I just got back late last night. So I'd like an opportunity to meet with him and see if, in fact, I don't want the court to enter an order finding him competent, and then 2 days later we're back and I'm asking for a re-referral because I don't believe he's able to rationally assist me.
Your Honor, I don't the name of the case, but I do have the docket number. It's an unpublished case from the Court of Appeals issued October 23rd, 2007. And this is in the Michigan Circuit Court bench book. And docket number of that case is 270414. And it said the trial court properly acted within its discretion in rejecting the defendant's request for an independent competency examination, where the request was made solely on the basis of the defendant's unsupported claim of bias by the Center of Forensic Psychiatry. And basically, Ms. Manarino is just basically saying unsupported, that I just think the Forensic Center is just saying he's competent because the time is coming to an end. But they always opined from the very beginning that they believed they could bring him back to competency before the period was up. And Ms. Manarino had no problems with them saying that then. So, Your Honor, there really is no good cause to order an independent. So for those reasons, Your Honor, I'm asking the court to either take the report over Ms. Manarino's objection, or schedule a competency report for a competency hearing for one day this week. Like I said, Your Honor, this case has been lingering on for quite there was never any issue with any findings of the Forensic Center point. So for those reasons, Your Honor, I'm asking the court to either take the findings or schedule a hearing.
As I've indicated already, this court needs good cause, and I don't find good cause given that defense counsel has not had an opportunity to interview her client and find that he's not capable of assisting in his defense. So he's been treated by the Forensic Center, and they opine that he is competent, that he is able to assist in his
I'm
defense.
sorry, Judge, I can't hear anything you're saying.
Can you hear me? Can you hear me now?
Yes, I can hear you now. Thank you, Judge.
Okay, sorry about that. Not sure what happened. But anyway, as I was indicating, the court does not have good cause to refer this matter for an independent, in that defense counsel has not established good cause that he's not able to assist in his defense. He's been treated by the Forensic Center over a period of time, and they opine that he is competent to stand trial after treatment and so forth. So I am going to adopt the report of the Forensic Center, set this matter for a preliminary examination, if that's what you're demanding, Ms. Manning.
At this point, yes, Judge.
Okay. We'll set this matter for a preliminary examination. Do you have all the discovery that you need?
I believe so, yes.
Okay. So we can go as early as May 7th at 10 o'clock.
Judge, if the court pleases, it's going to be a lengthy exam, so will we have at least a full day? We may need 2 days. This is.
I have nothing else. Well, I do have something scheduled at 1:30. I can do May 9th the whole day, from 10 o'clock until we finish.
I think we can make that work.
Ms. Manarino?
I can make it work. Would the court start at 9?
No, we won't have the prisoners over until 10. So we'll start at 10.
And going into Friday, if need be?
Although I know there's a lot of cases, the fortunate thing for me is that I have some very skilled attorneys here who don't take all day, even with this many cases.
There's a number of cases, Judge.
As much as humanly possible, Judge, we will try to work out stipulations, but essentially we're going to be doing 3 homicides and 1 AWIM consolidated.
Okay, so we'll see how it goes May 9th, and I can go until 10 to 4:30 if need be.
Okay, that works, Your Honor.
Okay? All right, May 9th, all day.
Okay, thank you.
Thank you.
Looking forward to it. Thank you.
Should be fun. Mr. Lamb. Michael Lamb, are you there?
Good morning, Judge King. I am.
Good morning, sir. What can I do for you?
Yep, I'm here for Mr. Dominique Thorton.
Thank you. Sir, in the Wayne County Jail, what's your name? Unmute yourself and tell me your name. You have to unmute yourself, sir. What's your name?
Dominique Thornton, Your Honor.
Okay. All right, we have Mr.
You want today?
Calling case number 2405-684101, because Lake Michigan versus Dominique Thornton. Defendant is charged in counts 1 and 2, criminal sexual, the 3rd degree.
Appearances for the record, please.
Good morning, Your Honor. Sonamov CCN on behalf of the people, P83923.
Good morning, Judge King, to you and your staff. My name is Michael Lamb, P number 79816, appearing on behalf of Mr. Thornton, who appears via Zoom. Mr. Thornton, will you please state your full name for the record?
How you doing, Your Honor? Dominique Thornton.
What's your pleasure, Mr. Lamb?
Your Honor, we are demanding an exam in this matter.
Okay. The court will continue to plead not guilty and set this matter for preliminary examination. How's May 6th at 10:45?
I'm sorry, May 6th at 10:45?
Yes, sir.
That's going to be a bad day, Your Honor. I have a couple matters scheduled that morning.
May 8th at 10:15?
May 8th at 10:15. Give me one moment. I'm having some internet issues. May 8th at 10 a.m.
10:15, sir.
10:15. I'm available that date and time.
I could do that as well, Judge.
All right, May 8th at 10:15, bond will be continued.
Your Honor, so may I address bond at this time?
Can I have something to say, Your Honor? Well, go ahead, Mr. Lamb, go ahead. I'm sorry.
Go ahead, Mr. Lamb.
Thank you, Your Honor. So, Your Honor, at this time, I'm requesting a personal bond for Mr. Thornton. So these allegations date back to 2022. Mr. Thornton is dealing with some other matters that were before you, Your Honor. He was given a personal bond. He has another case in which he has retained counsel. He has no history of failing to appear, Your Honor. He hasn't had any bond violations, no criminal activity pending those other two cases. His mother, he's going to be going to stay with his mother. His mother's very involved in his life and making sure that he is abiding by the terms of his bond as well as appearing in court.
So what are his other two cases before me?
Similar charges, Your Honor. I don't know if the other one was, I don't know if both of them were before you, but similar charges.
If I may, Judge.
Go ahead.
So we were here, it was probably a few months ago now. I'm handling one of the other cases. It's very similar in nature. It's another CSE 3rd degree incapacitated victim. We had the exam held. It was bound over. The other case involves, I believe, a minor, a 15-year-old who I'm not handling. Wilmeth is, and that also was in front of Your Honor. It was bound over. My two cases happened in 2022. I believe his other case happened in 2023. He was then in some sort of car accident. And one of the reasons the court essentially gave him, I don't think it's a personal bond, but gave him a lower bond was because of his medical conditions. However, it seems like now those have changed given the fact that he's able to walk. I think before one of the assertions was that he was handicapped to some extent. And I don't think that that's the case anymore. The people would object to any sort of personal bond in this case, given the fact that he's facing 3 separate victims related to criminal sexual conduct charges.
Can I say something, Your Honor, please?
It's up to your attorney.
So, Mr. Thornton, I wouldn't recommend that you say anything, but you certainly have a right to do so. If you are going to say something, I would strongly recommend that you don't say anything as it relates to the charges.
I just wanted to say, I am not a danger to the society. I have been on a tether, and I have been on I've been on the GPS tether. I've been going to all my court dates and everything. I haven't been having any problems or anything, and I've been going to work. And I've been going to therapy and my doctor's appointment. I'm still not right because I still have to go to therapy. And I lost my job, and I had 2 jobs. I lost one of my jobs, and I'm still working in my other job because I work with my father. But I go to all my court dates. I am not a danger to the society. I come home and I take care of my mom, and I do take care of what I have to take care of. So in the other 2 cases that I have against me, they're Upshaw. He's taking care of those. This case, I don't know anything about. I don't know who the person is or anything. They came to my house and picked me up.
Mr. Thornton, that's sufficient.
All right, I don't know enough about this defendant or his charges. All I know is that I have a defendant that's coming before me for a 3rd time. So there's a reasonable conclusion that this defendant may be a danger to the community, but I don't know. But I'm going to continue bond right now, but I'll refer to pretrial services for bond recommendation.
Thank you, Your Honor.
Thank you. Ms. Watt.
Thank you, Judge.
Thank you. Have a good day.
You as well. Take care.
Wayne County Jail, Effinger. Is that an officer? Can somebody call Wayne County to see if they're trying to get my baby in? Or what?
Coming your way, Your Honor. Let me cut my camera on. Here, Your Honor.
It's why I didn't have to call for you today. I'm impressed.
I'm getting ready to start a jury trial, so I was here. I was trying to get here before I started. We're just setting an exam.
You ready on Clemens?
Yes.
Okay.
Call in case number 2405-679-001. People of the state of Michigan versus Darnell Clemens. Beginning to charge in count 1, domestic violence, 3rd degree. Count 2, home invasion, 3rd degree.
Appearances for the record, please.
Good morning, Your Honor. Shelley Drain for the people, P number 60249. I'm standing in for the attorney of record, Ms. Carolyn Solari.
Good morning, Your Honor. On behalf of 41508.
What's your pleasure, Ms. White?
I'd like to set this matter for a preliminary exam, Your Honor.
Are you waiving your client's appearance?
Yes, Your Honor.
Court will waive the defendant's presence, continue to plead not guilty, and set this matter for preliminary examination. House May 6th at 10:45.
Your Honor, may I have a different date, any day that week in the noon hour, as I will still be in trial? Does the judge have any 12:30 dates available?
Can you do 12:30 on May 6th?
That's the first day of that trial. Yeah, I'll try and do it. I know the first day is kind of hectic, but I'll set it for 12:30.
Ms. Solari is not available on the 6th. She's available on the 7th through the 10th.
And I'm available the 7th. I already have one in Judge Giles at 12:30 on the 8th.
I can see you about.
Do 12 o'clock? May 8th, right next door.
Yes, Your Honor. That will.
May 8th at 12 o'clock. Bound to be continued.
Thank you, Your Honor. Have a good day, everyone.
Thank you, Judge.
Effinger is a case being transferred from Giles to us.
Oh. who's his attorney.
Okay,
Are you here on Effinger?
all right.
No, Your Honor.
What are you here on?
Mr. Mark.
Mr. Who?
Mark?
Mark?
They didn't bring him over yet. Your Honor.
Yeah, I believe he's in custody or was arrested over the weekend.
Did you want to wait on him? Or wait for judge?
So I believe we're set for preliminary, Your
Oh,
Honor.
it's up
So
to,
9 o'clock, Sam.
oh, that's my 9 o'clock.
Can we approach on that one, Your Honor? When the court has a moment?
Okay, come on.
So. Let's just do it, Mr. Mark.
I don't know. All right, thank you, thank you.
Jamil.
Yes, so maybe page number 2204576086. And I will ask Madam Clerk to amend the registered action page number 240444. Increase or release or indicate that the person that I can take on. And the DPS said anything further.
Excuse me.
We're waiting on your attorney, sir.
Yes, that's I was trying to add to it. I didn't know if he was in the courtroom or not, but I want to ask a brief breakout room for a brief moment.
He gets here.
You said when he gets here?
Yes, sir, he's not here yet.
Okay. Yeah, I know. They said that he was in here. Yeah, maybe I don't
Our cousin, I know the court, I'm welcome on the sixth, right?
Yeah, we can't.
No, I'm willing to the sixth, it's the sixth, yeah. No. All right, Mr. Kujan. Mr. Kujan?
Good morning, Judge. Sorry, wouldn't let me unmute for a minute there.
I think your client wants to go into a breakout room. You want to do that now or after?
I could talk to him now, please.
Right.
If that's okay with the court, if you have time. I did speak to him earlier this morning, though, so I don't know that it'll be too long.
Okay, give me a second.
Thank you.
Go ahead and join.
Judge, I don't know how to get Mr. Effinger out of the breakout room, but he just wants to set an exam date.
Okay.
Thank you.
It takes 60 seconds to bring them out.
All right.
Okay, we're ready on that.
Calling case number 2405-681501, people of the state of Michigan versus Michael Effinger. Defending the charge that count one, assault with intent to do great bodily harm, less than or by strangulation. Count two, assault with a dangerous weapon. Count three, domestic violence aggravated. Defendant has a habitual offender with offense notice.
Appearances for the record, please.
Good morning, Your Honor. Shelley Drain for the people, P number 60249.
And good morning, Your Honor. Jimmy appearing on behalf of Mr. Effinger.
Mr. Effinger, tell us your name for the record.
Michael Effinger.
And what's your pleasure, Mr. Kuzic?
Your Honor, we're looking to set an exam, please, if possible.
Court will continue to plead not guilty and set this matter for preliminary examination. House May 6th at 10:45.
May 6th at what time, Judge?
10:45.
Oh, you know what? Judge, is it possible to do Thursday, May 9th?
No, sir, that's my homicide day.
Okay.
I have another court date that day too as well.
Court's in the morning on May 6th.
Sorry?
What's the latest you can give me on May 6th?
I can do 12:30.
All right, 12:30 will work, Judge.
All right, May 6th at 12:30. Bond will be continued.
Yeah, he did want me to address his bond briefly. It's at 100,000 cash, but I think it's marked no surety, which is not appropriate. I'd ask if the court would consider making it 100,000, 10%, or at least clarify that it's cash surety if you're not going to do 10%.
Mr. Drain?
I got Shariki and Scunboard on money.
Just one moment, Your Honor. Your Honor, at this time, I'm going to ask for no change in bond except the cash surety. This was quite a brutal attack. This wasn't just a felonious assault with a knife. The allegation is that he choked her, bit her on the right side of her face, and then he grabbed a large kitchen knife and actually stabbed her. She had to have surgery. So this was a very serious assault, Your Honor. So I'd ask for the safety of the community, I'd ask for no reduction in the amount at this time.
What is the current bond?
Judge, it says $100,000 cash. What I'm asking is that even if the court is not inclined to do the 10%, it still has to be cash or surety. It can't just be cash, no surety.
You're correct. So the court set bond at 100,000 cash surety.
Thank you, Your Honor.
Thank you.
Have a good day, everybody.
Continue. Thank you.
Can I have paperwork, please? I just want paperwork to make sure. Sometimes Wayne County enter their paperwork kind of messed up down there. I know how they do. I was asking, can I have some type of paperwork to make sure to show that my bond is 100,000 cash surety and not cash?
How do you propose I'm going to give you paperwork, sir?
I didn't know if it could be faxed over. I'm not sure. I didn't. I was just asking the question, sir.
Let us do our job. We got it. Thank you. Have a good day.
Thank you. Thank you, Judge. Excuse me, Judge King.
Yes, sir.
Yes, sir. That's all I have for you for this floor.
Okay, thank you very much. Have a good day. Can't you? So. The judge does the PCC. Yeah. 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 So anybody can do a PCC. Anybody. One time it has to come back to do the exam. It's dismissed. Okay. So I heard surprised. And I'm looking forward. That happens when I'm looking forward to. Things done. Absolutely. Absolutely. Yeah. The thing is, the only caveat to the situation. I ain't running for money. I would have to step down for a whole year. Absolutely. We can change the world. I'll try. Yeah. Um, all right. Appreciate it. Ladies, who are you here on?
Maurice Jones.
That's who we call attorney. Do you know if he has an attorney?
Not sure.
Are you for Mr. Jones?
No, I'm with my brother.
Okay.
Mr. Charles, Mr. Daniels here.
Sir?
Mr. Daniels right here.
Mr. Daniels?
Yeah, to the call down again.
So they're getting turned from Mr. Daniels.
What's going on with that person?
They went for a transfer to come back and pick them up. It's about another 30 minutes.
You have anything ready on anything? 10 o'clock.
I'll find Mrs. Lynn here,
Sounds like the Christmas.
Why not?
Mr. Glenn.
Good morning, Your Honor. I had a call from IDS about a Maurice Jones.
You know you have an exam with me at 10 o'clock, right? Or is that your brother?
Has to be my brother.
Oh, okay.
Okay.
Okay, so you ready on Jones? Ready on Jones, Ms. Drain? Okay.
Call in case number 2.05-681701, people of the state of Michigan versus Maurice Jones. Defendant is charged in count 1, assault with intent to break out less than legal by strangulation. Count 2, domestic violence.
Good morning, Your Honor. Shelley Jones of the People, P number 60249.
And good morning, Your Honor. Luther Glenn P 38683, appearing on behalf of Mr. Jones, who appears via Zoom.
Mr. Jones, tell us your name for the record.
Maurice Jones.
What's your pleasure, Mr. Glenn?
Okay. Ask to set the matter for an exam.
Okay, the court will continue the plea of not guilty and set this matter for preliminary examination. How was May 6th at 10:45?
Okay, I have a trial that starts on Monday.
What day next week is good for you?
The 8th.
Okay, the 8th, May 8th at 9 o'clock?
Yes, Your Honor.
And that'll be in person, Mr. Jones, in 36th District Court. May
So
8th
what
at
time?
9 o'clock. May 8th at 9 o'clock.
All right.
Thank you very much, Your Honor.
Thank you.
Mr. Glenn, I will send you the discovery today.
Thank you.
Ms. James.
Judge, I think. Oh, she's right there.
All right, we're ready on oaths and Boston.
Call in case number 2206-005701. People of the state of Michigan versus Ibrahim Otumasi. Defendant is charged in counts 1 through 3, criminal sexual conduct, first degree.
Appearances for the record, please.
Good morning, Your Honor. Erin Wilmoth, P 82085, appearing on behalf of the people.
And good morning, Your Honor. Nicole James, appearing on behalf of Mr. Olin from Boston. Judge, I would ask to waive his presence for the purpose of this hearing. He is at the Forensic Center.
Are you a Republican attorney?
Say it one more time, Judge.
Are you a Republican attorney? You remember that? He wants a Republican lawyer. The court will waive the defendant's presence. Do we have a report back from the Forensic Center?
Judge, may I? So we don't have a report back. We received an email. I think Ms. Reynolds may have been copied on it from Valerie Kopka, Kopka, I believe, from the Forensic Center. She said that the final report should be issued by May 20th. Basically, she said it's not looking like he's going to be restored, and they would then file the civil commitment on him. But she had requested the court put a date out for the week of May 20th so that we could address that.
Okay, I can put it over to May 22nd.
Sure, that sounds good. And that would give us time, if the report's back on the 20th and he was not, and Mr. Olatunbosin was not restored to competency, then the Forensic Center can start their civil commitment process. And I think we have until the 28th. I think that's when the statutory period runs. So that would give us them enough time to do what they need to do for us to come back and do what we need to do, I think.
And that's correct. And that's a fine date for us as well.
Okay, May 22nd at 8:30. Bond, we continue. Thank you.
Thank you. Thank you.
Thank you,
Mr.
Your Honor.
Brown. Have a good day, ladies. Mr.
You
Brown.
too.
Good morning, Judge.
Good morning, sir. What can I do for you?
Anthony Daniels.
Mr. Daniels, okay?
Calling case number 2405-681601, people of the state of Michigan versus Anthony Daniels. Defendant is charged in count 1, weapons, firearm possession by prohibited person. Count 2, weapons, ammunition, possession by prohibited person. Count 3, assault with a dangerous weapon. Count 4, witnesses, bribing, intimidating, interfering. Count 5, license, documents, plates, forgery. Count 6 through 8, weapons, felony firearm. Count 9, domestic violence.
Appearances for the record, please.
And good morning, Your Honor. Brian Brown, P80560, appearing on behalf of Mr. Anthony Daniels, who is president. Mr. Daniels, please state your name for the record.
Anthony Daniels. What's your pleasure, Mr. Brown?
Your Honor, I was just recently spot assigned not even 5 minutes ago, so I would request discovery in this matter. So I'll be able to review that with my client and better advise him of what our strategy or options are. I guess ultimately set a preliminary examination, Your Honor. However, I'm in a murder trial that starts next week, which may go maybe two weeks. So with all due respect, we would respectfully request possibly an exam that's scheduled for the 27th, if that's not out of the court's.
Well, that's way out of bounds.
Right. So Your Honor, realistically, I'm not sure because, like I stated, I start a jury trial next Monday, the 6th, and it's going to be at least 2 weeks. That's what the prosecutor says. Hopefully it won't be, but I have to go by what they say.
I hate to overextend you, but maybe you can do it over a lunch hour?
Yeah, that'd be possible.
How about, does your judge, what judge are you in front of?
The Judge Donald Knapp.
Judge Knapp go on Fridays?
I'm not sure. But this trial he may,
Let's
because
take a gamble on Friday at 12:30, May 10th
okay.
at 12.
Very good. May 10th at 12:30.
It'll be here, sir, May 10th at 12:30, okay?
Okay, absolutely. And Your Honor, may I give Mr. Daniels my telephone number so he can give me a call and I can get his number. I don't want him to put his number over Zoom, but Mr. Daniels, you have something to write with?
We'll take care of it.
Okay, I appreciate that, Your Honor. Thank you.
What's the number?
313-671-4139.
We'll get that number to you, sir. All right, thank you, Mr. Brown. Have a good day, sir.
You too, Your Honor. Thank you.
Give him this one.
Okay, I gave you 20.
You gave it to him already?
Yeah.
Okay. All right. Mr. Johnson, are we ready on your place?
I have no idea.
No,
You still not here?
when, President.
Okay. Anthony Collins.
Should be here, but not. So, Collins, step out.
Calling 2456635, people of the state of Michigan versus Anthony Benjamin Collins. Defendant is charged in count 1, assault with intent to murder. Count 2, assault with intent to do great bodily harm, less than murder or by strangulation. Count 3, assault with a dangerous weapon. Count 4, weapons, firearms, possession by a prohibited person. Count 5, 6, and 7, and 8, felony firearm. Count 9, domestic violence. Defendant has a habitual offender third offense notice. Appearances for the record, please.
Good morning, Your Honor. Shelley Green for the people, P number 60249.
William Ben, D 36794 on behalf of Mr. Collins. Today is the date and time set for preliminary examination. Are you ready to proceed?
Your Honor, I have opposition, but the complaint is not here yet. Can I move to 7?
Sure.
Yes.
Okay.
That's all it's called, 36 days before. We got a Lamb at 9 o'clock.
Calling him Martin.
Yeah, they didn't bring him over. They say he was on video this morning. He wasn't on video.
I was on video. He's still posting clips.
Yeah, that's what I told him. So I guess they got to go back and get him. They brought over another guy, but they didn't bring him.
So what time am I working with, Mr. Johnson?
I'm sorry, Your Honor.
What time am I working with? What time do you have to be somewhere else?
I have 1 hour, Your Honor. With a 20-minute use.
What about the rest of your day?
It's even worse. Today is just a horrible day.
What about this afternoon?
No, that's what I'm saying. The afternoon is worse, Your Honor. If I have to wait around this morning, but it.
Mr. Green, are you ready on Collins now? Recalling case 2456635, People versus Anthony Benjamin Collins. Are you ready to proceed?
Yes, Judge.
How many witnesses?
Just one minute.
Okay, call your witness.
At this time, please indicate the at this time, people will call Officer Marcus Carter.
Sir, please give your name and spelling to the court reporter.
Yeah.
Please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Yes. Thank you, sir. Please have a seat and witness spot next to me.
Thank you. All right. Good morning. Please state your name once again for the record.
Yes, it's going to be Marcus Dalton.
Okay. Officer Goddard, I'm going to be asking you some questions today. If you don't understand something, if you want me to repeat it, please let me know. All right?
Yeah.
Thank you. Thank you, officer. I want to bring your attention back to the date of April 7th of this year, 2024. Do you remember that date?
Yes,
Okay. And what is your occupation?
police officer,
And what township or city are you in?
city of Detroit.
Okay. And were you so employed in that capacity on the date of April 7th of this year, 2024?
Yes,
Were you working and on duty?
yes,
Okay. Were you alone or with a partner?
with a partner,
What was your partner's name?
girl young,
Okay. And what was your duty or assignments on that day?
patrol.
Okay. And were you in full uniform?
Yes,
Were you in a fully marked scout car?
yes,
All right. And so around well, just past midnight or somewhere around midnight, was there anything that you noticed or a police run?
yes, we had a police run.
Okay, and what was the nature of the police run?
A woman called stating that
Here's the, not only for the truth of the matter asserted, but the nature of the call, for the ticket for that limited purpose.
Thank you, Judge. Okay, what was the nature of the police run?
yeah, she called stating that someone kicked in her door and was chasing around the house with a gun.
Okay, and so was there a location given?
Yes,
And what was the location?
I don't remember the exact address.
Do you remember the street?
No,
Do you remember the, any of the streets around that area?
no,
Okay. Do you remember the woman's name?
no,
Okay. Did you arrive to that location?
yes,
Okay. And when you arrived to that location, first, were you driving the vehicle or with someone else?
I was driving the vehicle.
Okay. So when you got to the location, where did you park?
I parked inside, it's like an apartment complex, I parked inside of the complex.
Okay. And what observations, if any, did you make right then?
Right before I arrived, before I parked, I observed a vehicle pulling out of the parking lot after I heard gunshots. So first, I did a traffic stop on that vehicle, and then I observed it was a victim, and I observed bullet holes in her car. So then I went back to the scene in front of her house, and I observed shell casings. So my partner, I canvassed the area with another partner, while my primary partner was talking to the victim, getting the story.
Okay. And when you canvassed the area, what observations did you make?
Yes, I observed a male walking in like the courtyard.
Okay. And where was the courtyard in relation to the building?
Like right next door.
Okay. And what did you observe of this man?
This man was just walking over there. I went to talk to him, and he stated he was going to his girlfriend's house, and he stated her name that I remember at the time.
Okay, what was her name?
But I'm not sure.
Okay. Do you have your report with you?
No.
Okay. If you reviewed your report, would that refresh your memory? Would that
Yeah.
possibly, Your Honor, may I approach the witness?
You may.
I'm handing you that document. Is that a police report? Is that the police report that you're referring to?
No.
No? Okay.
Okay.
Okay. All right, what did I just hand you?
My police report.
Okay, and is that the police report regarding the incident that you just testified about?
Yes.
Okay, could you take a moment and review that report?
Okay.
Thank you. After a review of your report, does that, do you recall now what the name of the complainant was?
Yes,
And what was the complainant's name?
Laquita Watts.
All right, thank you. All right, and so the person, so you said you ran into a male, who said he was there to visit his girlfriend?
Yes, he said he was going to his girlfriend's house.
Okay, and did he mention her name?
I don't recall.
Okay, and so what, if anything else, did you notice about this male?
So before I walked over there, she gave a description and he matched. He matched the description.
Thank you, Judge. Okay, could you say what you were thinking again?
Yes, she gave a description and he matched the description.
And when you say she, who are you referring to?
Laquita Watts.
Okay, and, okay, so she gave a description of who?
Her ex-boyfriend that shot at her.
Okay, and so you're saying that the description that she gave matched the description of the person that you saw in Portland, is that right?
Yes.
All right, and, do you remember what that description was?
Yes, it was a light-skinned man with dreads.
Okay, and so you say that that's why you were talking to this individual?
Yes.
Okay, and so after he stated, was there anyone else right around that area?
No.
Okay, so after he stated he was there to visit his girlfriend, what happened next?
Yes, I detained him and I walked over to where my other partner was and where she was, and I asked, what was the name of your ex-boyfriend? And she gave Anthony Collins.
Oh, here's a.
Thank you. And Your Honor, I would just indicate to the court, that, this is the only witness that I'm calling, and so I am, going to be proceeding on questioning, pursuant to MCL 768.72C, which does allow for information from the, victim through the justified section. Thank you. All right, and, and this is Ms. Watts that you were speaking with?
Yes.
Okay, and what did Ms. Watts say?
She said her ex-boyfriend's name was Anthony Collins.
Okay, and do you see the person in court today that you took into custody that day?
Yes.
Could you indicate where he is and what he's wearing today?
He's wearing green with his dress to the back.
Thank you. Your Honor, please let this record reflect that this witness has identified the defendant Anthony Collins.
So moved.
Thank you. All right, and what other observations, if any, did you make?
He was walking from an area underneath like a light pole. So after I detained him and put him in the car, I went to canvass the area.
And why did you go to canvass the area?
For the weapon.
Okay, and what observations, if any, did you make as you canvassed the area?
Yes, I recovered the weapon that was underneath the light pole where he was walking from.
Okay, so can you describe this area? What it looked like?
It looked like, so it was an apartment complex, they all look very similar. It was like a couple of house.
Okay, so an apartment complex, and you said there was a lighted area?
Yes.
Okay, and was that lighted area, was it like a street light? Was it a light attached to the building?
Yeah, it was a street light.
Okay, all right. And so how far away from the building were you when you made the recovery?
So the sidewalk is right in front of the building. It was, the pole is really right after the sidewalk.
Okay.
It's not in the street, it's like on the grass.
Okay, so if you saw the gun on the grass?
Yes.
Okay, and how far away was Mr. Collins from that specific area when you saw him? Where you saw the gun?
Around 10, 15 feet.
Okay, was there anything else around the area?
No.
Okay, you didn't make any other observations?
No.
Okay, and you recovered that weapon?
Yes.
Okay. You indicated that you heard shots as well.
Yes.
And at what point was that?
When I was arriving.
And how many shots did you hear?
I'm not sure the exact amount of shots.
Okay, when you heard the shots, did it sound close by or far away?
Sounded very close.
Okay, and, at that time, did you see anyone in the area?
No, it was dark.
Okay. What information did you hear from Ms. Watts?
So after the shots, and I pulled the vehicle over, I told her to put her hands on the window. She did. And she stated my ex-boyfriend who shot her.
Okay, so she said her ex-boyfriend just shot at you, and she gave you the name.
Yes.
Okay, and you identified that person's name as Mr. Collins in the courtroom here today, correct?
Yes.
Okay, and was there anyone else around the area? Okay.
Yes, I walked up to the house, her brother came out. I detained him too, because I wasn't sure who the offender was, and he stated his name.
Okay, were you able to determine that the person that you saw was not Mr. Collins?
Yes.
Was someone else?
Yes.
Okay, and that person was related to the complainant?
Yes.
Okay. All right, and then you indicated that, how much time had gone by between the time that you, saw Mr. Collins around the area where you recovered the weapon, and the time that you saw him and the time that you actually recovered the weapon? How much time?
Maybe around 6-7 minutes. I'm not sure the exact amount.
Okay. Did you see anyone else around that area, during that time?
No.
I have no further questions.
Yes. Officer, you stated that you recovered a firearm, is that correct?
Yes.
And what type of firearm was that?
It was a blue torch.
Now, did you recover any type of shell casing to put those on evidence?
Yes.
And how many shell cases did you recover?
I'm not sure the exact amount. Look back at my report. Sure. So my partner recovered the shell casings. I just recovered the firearm.
So you didn't recover the shell?
No, sir.
Now, do you have any evidence at all as to whether or not the shell casings recovered by your partner matched the gun that you found?
Yes.
Where is that?
The evidence.
Do you have a ballistic report? Do you have a ballistic report showing that the shell casings recovered by your partner matched the gun that you say you found?
No, I do not.
Now, you stated that when you got there, you saw Mr. Collins in a courtyard.
Yes.
And you stated that he was near a light post.
No, he was walking away from the light post.
He was walking away from a light post. Yes. You stated that this was an apartment complex.
Yeah.
What do you mean by that?
Like all the houses are very close. What else is close?
All right, was this a parking lot or was this a driveway?
Parking lot, what do you mean?
All right, well, when you drove into this area, how many cars were parked outside the building?
It was a parking lot.
All right, how many cars were parked out?
I'm not sure.
Now, did you see Mr. Collins toss or throw or drop anything?
No.
Did you see him possess anything?
No.
Now, when you got there at this location, you stated that you heard gunshots, is that correct?
Yes.
Did you see where the gunshots were coming from?
No.
Did you have your dash cam on?
No.
Did you have your body cam?
No.
So, did your, when you recovered this gun, did you have your body cam?
Yes.
When did you turn it on?
I turned it on right after I heard the gunshot.
And, did your, body cam show Mr. Collins in that area
At what time?
at midnight, 12:30?
The body cam would speak for itself. That's evidence.
Now, you stated that when you were out there, no other individuals were there, is that correct?
Besides, yes, the victim and her brother.
Now, did you see any bullet holes in this car?
Yes.
Did you take any pictures of those bullet holes?
No, it's on body cam.
How many people were in this car again?
It was just her in the car.
Yes, sir. And, did you detain her or have her go to the station for more questioning?
No.
She just drove off?
No, she didn't drive. Well, my partner stayed with her.
Nothing.
Can you redirect?
Your Honor, I have nothing further of this witness. I am going to ask.
Okay. All right, thank you, sir. You may step down. Let me speak to you just for a second. Something unrelated. Oh, your next witness?
Thank you, Your Honor. Your Honor, at this time, the people will call Officer Gerard Young.
Yeah. Sir, please step forward. All the way up, sir. Give your name and spelling to the court reporter. R-A-G-U-S. Please raise your right hand, sir. Swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God. Thank you, sir. Please have a seat in the witness box next to me.
Thank you. All right, please state your name one more time for the record.
Jared Young.
Okay, and Mr. Young, I want to bring your attention back to the date of April 7th of this year, 2024. Do you remember that date?
Yes, ma'am.
Okay, were you working on that date?
Yes, ma'am.
Where were you working?
I was working in the 9th precinct.
Speak to the microphone, sir.
I was working in the 9th precinct.
Okay, and what is your job?
I'm a police officer.
Okay, for what city or township?
Detroit.
Okay, and how long have you been a police officer?
1 year.
Okay, so you were working on the day of April 7th this year, 2024. Is that right?
Yes, ma'am.
Okay, and were you working alone or with a partner?
I was working with my partner.
Okay, what was your partner's name?
Marcus Stockton.
Okay. And what was your assignment or your duties on
Routine patrol, answering police calls.
that? Okay. And around midnight on that day, did you respond to a call?
Yes, ma'am.
Okay. So were you in a dark scout car?
Yes, ma'am.
Were you in full uniform?
Yes, ma'am.
Okay. Were you driving the scout car?
I was not.
Okay. So what was the nature of the police run?
It was a burglary of an occupied residence. It was in the 5th precinct, somewhere on Kitchener.
Okay, so that's Kitchener Street in the city of Detroit.
Yes, ma'am.
Okay. And so when you arrived, did you arrive to that location?
Yes, ma'am.
Okay. When you arrived, what observations did you make?
I heard approximately 10 gunshots, what I thought were 10 gunshots, and then I saw a brown Ford Flex pull out of the parking lot. Got any lights on? So me and my partner did a traffic stop on that vehicle. and the driver identified herself and stated that she was just shot at in front of her apartment.
Okay. So it was a female who was in the vehicle? Was there anyone else in the vehicle with her?
No, there was not.
Okay. And what was her name, do you remember?
I do not recall the first name.
Okay.
The last name was Watts.
Watts, okay. And if you, reviewing your police report, refresh your memory?
Yes, ma'am.
Okay, would you take a moment and review your police report? You want?
I do not.
Okay, Your Honor, may I approach the witness?
You may.
All right, I just handed you a document. Do you recognize that document?
Yes, ma'am.
What is that?
It is my police.
Okay, could you take a moment to review that? All right, are you done?
Yes, ma'am.
Okay, thank you. And does reviewing your report, refresh your memory as to, the full name of the witness that you spoke with?
Yes, ma'am.
And what is the name?
Deon Marsh.
Okay. So what do you recall Ms. Watts saying?
She stated that her ex-boyfriend came over to the location, kicked the door down. Then when she attempted to leave the location, he fired shots at her vehicle and she was leaving.
Okay. And did you see any markings of any, maybe bullet holes or anything in her vehicle?
I saw what appeared to be a bullet hole in the rear driver's side door near the rear tire. And it sounded like arrows coming from the tire, which would make sense from the bullet striking the tire. And there were 10 brass shell casings at the location.
Okay, 10 brass shell casings. Okay, and where did you see those?
Yes, I did.
Okay, and where exactly did you see those?
They were in the parking lot, in front of the location.
Okay, and was Ms. Watts specific with you as to whether whether she was outside of the vehicle or inside of the vehicle when she was shot at?
No, she just stated that when she attempted to leave the area, that's when she got shot.
Okay, and did your partner stay with you the whole time, or was he doing something else?
No, he was doing something else.
Okay, all right. Okay, I have no further questions at this time.
Do you know whether or not this individual was in the car when these shots were fired?
Can you repeat that, please?
Do you know whether or not this individual was in the car when the shots were fired?
No, I didn't.
Is this parking lot or building a green light location within surveillance cameras?
No, it isn't.
And approximately how many cars were out there in the parking lot?
I do not recall.
Was any other individuals out there in the parking lot?
No.
Now, when you arrived at this place, you stated that you heard gunshots, is that correct?
That is correct.
Did you see where they were coming from?
No, we did not.
You stated that you recovered the shell casing, is that correct?
That is correct.
Now, do you have any ballistic information to show whether or not those shell casings belong to the gun that was found in the area?
No, I didn't.
Nothing.
Can you read her? Officer, the shell casings that were recovered from this location, were you able to tell us the caliber of the shell casings?
Yes, they were 9mm.
9mm. And you said your partner, did you ever see a weapon that was recovered by him?
Yes.
What kind of weapon was it?
Was it the G2C Taurus and steel?
Do you know if that weapon fires 9mm? Shell case?
It had two 9mm bullets inside of the firearm.
Any questions based on my questions?
No further questions.
Okay. Thank you, sir. You may start. Any other witnesses for the people? Any witnesses for the defendant? No, yeah. People.
For this time, I would move to find over as charged as to count 4, weapons, firearm, possession by a prohibited person. I would indicate that I do have a certified copy of prior conviction of Anthony Collins, specifically that on the date of February 14th of 2019, Anthony Collins was sentenced for the crime of felonious assault, which was prohibited from being in possession of a weapon.
I stipulate, for example, the court receives that stipulation. The argument is final.
Yes, Your Honor, I would object to the bind over. Both officers stated that when they arrived at this location, they heard gunshots, but neither one testified to where gunshots were coming from. And more importantly, there's no testimony as to whether or not this young lady, Ms. Watts, was even in the car when the gunshots were being fired. So I mean, if you have a assault with intent to murder and you're making a claim that bullets from a gun hit the car, you have to show that the person was inside the car. So I don't
about
believe
her alleged testimony. He shot at me.
She didn't say that. This is what the officers say.
Yeah, that's what they said. She said he shot at me.
I don't think they've made out a case for assault with intent to murder, and I would ask this case to be dismissed.
Mr. Grant.
And we had testimony from the 2 officers that arrived on the scene. In this case, both officers testified that they actually heard shots as they arrived on the scene. And the police one was for breaking and entering or burglary, not of shots fired. So by the time they get there, now they hear shots fired. So now that's when the situation changes. So both officers testified they hear shots fired. The first officer, Officer Gillard, testifies that he did not stay with the complainant in this case, but he went to investigate right away. He did identify the defendant, Mr. Collins, as being right in the area right there. He asked what the officer asked what he was doing. He said he was there to visit his girlfriend, and he identifies the girlfriend as actually the complainant and would be a wife. He also indicates that he matched, the officer indicates the defendant matched the description that the complainant gave. Officer places him under arrest, then goes back to canvass the area. Officer goes to right where, a lighted area, right where the defendant was, and locates a weapon. Officer Young testifies that he stays with the complainant, talks to her about what happened. She says that her boyfriend broke in the house and she tries to leave, and he was shooting at her. He observed bullet holes in the car, and I believe in the tire, because he could hear that air was even coming out of the tire. He also recovered shell casings, and he says 10 shell casings that he recovered, 9mm shell casings, and there was also 9mm bullets in the gun that was recovered. Your Honor, I think that it's very clear that defendant, for mind over purposes, that defendant was there in the area, shots were fired, a gun was recovered, shell casings were recovered, and the cabin statement of the complaint. I have to remember.
This is as strong a circumstantial case as we'll ever see, in that as the assistant prosecuting attorney pointed out, the nature of the one was a home invasion. Officers arrive at the scene, they hear gunshots, and they see a car leaving or attempting to leave the location. They stop the car, and the complainant in the car says that her ex-boyfriend shot at her. They look at the vehicle and they see, what do they see? They see gunshot or bullet holes in the vehicle. Then they see the defendant just happens to match the same name as the complainant gave, as well as the description. And then they look and canvass the area where the defendant was just recently at, and they recover a gun. I submit to you, when you fire a shot, or you allegedly fire shots into small confines of the car, there's a decent case to be made that was with the intent to murder. Anytime you're firing shots into the vehicle, the assault with the intent to do great bodily harm, I guess is going to be a lesser included, as well as the assault with a deadly weapon. People have established that the defendant was a felon and should not have been in possession of a firearm. The felony firearms go over, as well as the domestic violence. The court is satisfied that people have met their burden of probable cause as it relates to the charges contained in complaint form. The court finds those charges were committed in the city of Detroit. The court finds probable cause to believe this defendant. The defendant will be bound over to Wayne County Third Circuit Court of Criminal Division proceedings. His arraignment on the information date and time will be May 6, 2024 at 9:00 a.m. Bond will be continued. Hey, please support me. We have the issue. Decision. Not making it personal. Oh, okay. I refer to the officers. Can you guys give me the number to the Wayne County Jail?
2240788. I just called it back at 10:43. They said they were short on CTU, so it's gonna be a minute. 0788. Yeah. Usually it's gonna be a waiver. Usually. Yeah.
Here's the usury file.
This is what.
Okay, I'll try. Okay. Oh, yeah.
Okay, they said Martin is coming right now. I apologize, counsel. You know I don't operate like this.
I know, Your Honor, but it's not your fault, but I am. My whole morning and
Anybody have a call for you?
I appreciate it. Is it safe, Your Honor, is it safe to say when he comes, he's an immediate, I mean, I'm still gonna need a couple minutes with him.
Yes. Okay. Whatever you need to do, just let me know. I got you.
An adjournment would be great.
No, I don't want anything but that. I don't want to do that.
I understand, Your Honor, thank you.
Are you his counsel? Mr. Bennett? Just for that purpose. Going your 2 cents. Ms. Casco here?
Silver's on that case now.
Oh, it's, you know. You know, you agree.
Hawkins, right?
Yes, sir. Calling case 24-56553 for the state of Michigan versus Kenyale Eugene User. Defendants charged in count 1 child abuse, 2nd degree. Count 2 assault with a dangerous weapon. Count 3 felony firearm. Appearances for the record.
Thank you, Your Honor. Erica Moses on behalf of the people, P78491.
Good morning, Your Honor. Neighborhood Defender Service by Summers Brush number 85828 appearing on behalf of Danielle User, who is present at court. Mr. User, please state your name for the record.
Been here, a little louder for me. Kenyale Eugene User. Daytime separate from their examination was rushed.
Yes, Your Honor. At this point, I have talked to my client, and we are prepared to waive the preliminary examination today.
Sir, please raise your right hand. Swear or affirm to tell the truth, the whole truth, nothing but the truth, so help you God?
Yes.
Thank you, sir. You understand you have a statutory right to have a preliminary examination. By waiving the same, that means you won't have one, and you'll be bound over to Wayne County Third Circuit Court as you stand charged with 21. You understand that, sir?
Yes.
You understand the nature and the purpose of the preliminary examination?
Yes.
You understand if you were to have one, the prosecution would have to establish that the crime you're charged with was committed in the city of Detroit, that was probably cause to believe you committed it. Yes. Is anyone forcing you to waive your right?
No.
Does anyone promise you anything?
No.
Are you waiving your right freely and voluntarily?
Yes.
Any objection from the people?
No, Judge.
The court finds defendant's waiver is made knowingly and voluntarily. Therefore, binding the defendant over to Wayne County Third Circuit Court Criminal Division for further proceedings. There's a arraignment on the information. The date and time will be May 13th, 2024 at 9:00 a.m.
Thank you, Judge.
Your Honor, if I could address Mr. User's bond. Last time in front of, when we adjourned this matter, the court amended Mr. Usury's bond to 9 a.m. to 5 p.m. when he began untethered. Since then, he has gotten a job. However, the hours are 2 p.m. to 8:30 p.m. I have the employment verification form working with Green Tea Innovation LLC as a home improvement personnel. I asked if the court could amend the hours from maybe that he needs to be at home from the hours of 11 p.m. to 7 and to 8 a.m. per hour. The court would like to structure it so that he can go to work without violating his bond.
Speaking.
I have no problem with that.
Okay, so give me a proposed order to that effect.
Thank you, Your Honor. I will. Oh, and then if the court, for his tether officer, if the court could sign this, if he could sign this form, so the tether office, it's the electronic monitoring from employment verification form.
You want me to sign?
Yes. The tether, it just says that his work hours are Monday through Friday, 2 p.m. to 8:30 p.m.
Oh.
Thank you.
So why do I have to sign this? Don't they call and verify?
Yes, sir. Mr. Usury is just going off what his tether officer requested of him.
Because I don't know these are his work hours.
He told me it was getting filled out. They told me I had to bring it here to get it before and bring it back to them. And I go,
What I suggest is that you get something from your employer stating what your hours are.
That's from my employer, sir. His information is there.
Okay, well, this is nothing for me to sign, so.
I understand, Your Honor. I will.
The order that you have should suffice.
I understand. Yes, thank you.
We're gonna leave you in there. For all the wrong you've done. For all the wrong you've done in the past, we're gonna leave you in there. How you doing?
Woo, I'm doing fine. Oh, man.
You've been in there for a while. Mr. Branson has a lot to say today. Do I have anybody here on Burks? Here on Burks?
Yes.
Calling case 2455984, people of the state of Michigan versus Fabian LaShawn Burks. Defendant is charged with count 1 assault with intent to do great bodily harm, rescue, murder, or by strangulation. Count 2 domestic violence. Defendant has an original offender second offense numbers. Appearances for the record, please.
Good morning, Your Honor. Shelley Henry, People, P number 60249.
Good morning, Your Honor. Sarah Kraus, P81830. I'm standing in for the attorney of record, Gabby Silver, for Fabian Burks. Mr. Burks, can you state your name, please?
Fabian LaShawn Burks. It is daytime set for preliminary examination. Are you ready to proceed?
No, Your Honor, I'm not able to proceed at this time. The complaining witness was notified of today's date and time for the exam. She is not present. I cannot proceed without her testimony today.
Defense would move for a dismissal, Your Honor.
So, or the court will dismiss this matter without prejudice. I just need a dismissal order. Okay.
And Judge, he is wearing a GPS tether. I indicated to remove the tether on the order.
Okay. Mr. Harris.
Yes, sir. When we approach me and Mr. Lockville, just briefly.
You and who?
Mr. Lockville, prosecutor. We approach it.
Sure. How do I get a murder exam set for 10
I don't know, Judge, how you did that. I thought it was right too.
I'm sorry?
I thought that was right too.
It is.
It's it, 10:45.
So.
That's fine. Yeah, no, that's fine. Yeah, this is. Oh. It'd be easy. Okay. I'm ready whenever you want.
All right, let's have Anthony Hawkins. Calling case 2456747 for the state of Michigan versus Anthony Hawkins. Defendant is charged with count 1 homicide, murder, second degree. Defendant has an additional offender third offense notice. Appearances for the record, please.
Good morning, Your Honor. Steve Lockwood with People, P70668.
Good morning, Your Honor. Wyatt here is 354-891 on behalf of Mr. Ed Hawkins, who stands to my left. Mr. Hawkins, give your name for the record.
Anthony Hawkins. There's a daytime set for preliminary examination. We did have some sidebar discussion.
Your Honor, the prosecutor and I have had a discussion about this matter. We're asking this court to adjourn the matter for several reasons. Number one, the prosecutor needs another witness to testify, and I need more discovery. There's some digital discovery that I had time to get. Got it. I'd ask this court, but we both would ask this court to adjourn.
That's correct, Judge. Based on my discussion with Mr. Harris, yes, we would agree that.
So I'd also like to have this witness.
next week you would be available.
Next week, as in May 7th?
Yes, I think we could do May 7th.
May 7th at 10 o'clock?
Got several matters I got to handle.
All day?
Well, if the court, well, let me ask this. Would the court consider doing this in the afternoon?
1:30?
1:30 is perfect.
That'll work for me. Actually, I have a 1:30 schedule.
We'll wait. We'll wait.
How many minutes?
There's, 3, I think, all the officers. It should be fairly quick.
Yes, it should be fairly quick, and it may be a waiver if we work some things out. So, yeah, we'll wait on Tuesday. That's a good thing.
All right, May 7th at 1:30.
Okay. Judge, may I address mine?
Okay.
My client is, got a $250,000 cash amount. He can't make that fine. There are circumstances within this case that may cause the prosecutor to consider producing a second-degree murder. My client has children who are in the care of their aunt. He owns his own home, and he would go back to that home. I understand that he has a previous conviction, but this is a situation that, well, he's not a danger to society from the standpoint of physical violence with society. This is a situation where the deceased was living with my client with my client's permission. So there was a situation that occurred there at the house that caused it an unfortunate circumstance. My client is not going to run for return to court. He's 57 years old, so he really can't run all that far, and got a number of ailments. I would have asked this court to reduce his fine to $50,000, cash surety or 10%.
After discussing the matter with Mr. Harris, I agree with everything you said. People leave them for discretion as far as fine.
All right, the court will reduce the fine of 50,000, 10%. It will be on GPS house arrest. Your house will be your jail. Got it? The bond reduction.
I gotta hear you.
Gary saw you.
Right here. Good judge.
Go in the hallway to tell my client.
Okay.
Check over the box.
Calling case 2456726 to the state of Michigan versus Gary Robert Saul. defendant is charged in count 1 assault with a dangerous weapon, count 2 interfering with crime report, count 3 domestic violence. Appearances for the record.
One, Your Honor, shall we drink number 60249?
Good morning, Your Honor. Richard Van Fleet, 39845 for the defendant's game time. Gary Robert Salyer.
Dedicated time set for preliminary examination on each grade.
No, Your Honor, the complainant is not present, and I cannot see without the testimony.
Your Honor, we make a motion to dismiss.
So order, the court will dismiss this matter without prejudice.
Thank you, Your Honor.
Okay. I just need a dismissal order, Mr. Vance. Dismissal order, Mr. Vance.
Yes.
Martin is here, they about to bring him up.
Okay, beautiful. I have parties here on Mosley. Parties on Mosley. Mr. Chapman, how you doing?
Good morning, Your Honor. How are you?
Good. Who's our APA on Mosley?
Mosley.
Ms. Jones. Are you aware that we have a co-defendant?
Yes.
So we're gonna put the whole thing over to the vote.
Well, I don't want to argue the case up. One of the things we'll take up in the question 5. Evidence will show that nobody hurt, there's no. And Zoom data, so we hope the court will mark that.
All right. Take him.
I understand the issue of traditional economy not having to do the pre-grant twice. And I wouldn't even be pressing the issue if he were on and the GPS tether would satisfy any concerns I think about his whereabouts.
Where is, do we have Mr. Bowen here?
Yes.
Hi.
Come on, step up.
Let's listen for the questions. Calling case 2456718 for the state of Michigan versus Lester John Mosley. Defendant is charged in count 1 assault with intent to murder, count 2 assault with a dangerous weapon, count 3 felony firearm, count 4 felony firearm. Appearances for the record.
Good morning, Your Honor. Shall we drink this equal to number 60249?
Good morning, Your Honor. Claude Chapman, P69850 on behalf of Mr. Mosley, who is present to my left.
Tell me your name for the record, sir.
Lester Mosley.
So there's a big time set for preliminary examination, but I understand that there is a co-defendant on this matter that has just recently been brought into custody and has a bond redetermination hearing tomorrow.
It's my understanding as well, Your Honor.
I do understand. I believe the co-defendant was arrested this past weekend.
Right. So that being said, I would imagine that people don't want to do this exam twice.
I would prefer to do it both, to do one exam for both of them. Exactly.
I want to take
All right.
We are not opposed to adjourning this matter. And we do understand. However, would like the court to, I think I raised it the last time we were here for the cause conference, that Mr. Mosley is presumed innocent. He has a previous history of any type of violence. He's not a flight risk. I would think that a personal bond with a GPS tender would satisfy any concern that the court might have about where his whereabouts are. I would respectfully ask the court to grant a personal bond with a GPS, and at that point, we would have no opposition to putting this matter over.
First of all, I believe defense counsel has requested additional discovery as well. Is that correct?
The only additional discovery that I requested, there are allegedly several statements made by the complainant in this case, and several of them are audio video. What we're requesting is a verbatim dictation. We can't make out everything that he says. And we believe that the statements, especially in so much that they conflict all over the place, we need a verbatim dictation of the statements that the complainant has made.
I'm not sure.
A dictation, in other words,
transcription.
Yes. Of the statements that he made 3 statements. He made a statement when he was first came to the barbershop that night. First out the orders with one officer. He subsequently made a second statement when he was sitting in the barber chair on the inside of the barbershop. And then the third, a week later, he made a statement.
So who are you asking to do this? Who are you asking to do this?
I would ask the prosecution provide us with the dictation.
Why can't you do it?
Because if we were to do it, it still would be a question of how authentic it would be. And it would also be a burden on Mr. Mosley, because he does not have the resources to do that. It is not a burden on the prosecution to produce a dictation. Thank you. I don't know. What do you think?
I've not ever received a request like this, so I don't know the process of how to.
Your Honor, we do not need the dictation for the preliminary exam. The dictation, that's the transcript.
So I just want to concern myself with the exam. I don't care what you guys do.
Yeah,
if it gets found over, that's none of my business.
If it's found over, we can make the stip and order with the circuit court, or we can file a motion with the circuit court. We do not need the.
All right, so let's deal with what we're going to do here today. No, I don't need to talk about that.
Thank you. So as to your question, what I would need to report is that this is a case that is turned out into murder. There were shots, the allegations that there were shots fired at the complainant by this defendant, not by the co-defendant, but by this defendant. And I think that these are very serious allegations. And so for the safety of the community, I imagine that there is I'm not objecting to a reduction, but not a increasing amount.
Your Honor, if I might add, as I said, of my own peril, I'm not trying to argue this. The evidence is going to show that there were shell casings found near the scene based on a shots fired report. There will be evidence to show that none of those shell casings has been documented that they're related to this incident at all. Claimant in this case indicates that a tire was shot out on this car. However, the car was not impounded. There's nothing to document that anything related to this car was the result of any type of gunshot. There will be no evidence to show any type of projectile is in any way connected to the shell casings that were found near the scene of what was allegedly happened. And to illustrate, as I said before, we can document I can provide the court with photographs, diagrams of the area which would document, Your Honor, that there's nothing to document anything that shots were fired at this individual, or that any type of firearm or any type of bullet that's connected to this case has been documented.
So, Your Honor, I have a complaint who is present and ready to report with you today. And this complaint would state that he observed the defendant fire approximately 9 gunshots in his direction from inside of the vehicle, striking the complainant's vehicle.
And I would add to that, the police reports will say that the complainant heard gunshots and fled west on West Warren. On another occasion, he said that he saw his ex-wife in an SUV, Edge SUV. At another point, he says that there was a white Yukon SUV. He's made multiple statements in Baltimore, and I think all of that will come out of the preliminary exam.
I'm starting to want to do this exam now.
But what I'm actually saying, Your Honor, that a personal bond, high personal bond, he has
High personal bond means absolutely.
well, a high personal bond or just a low personal bond. But a personal bond with a tether, a GPS tether, would should allay any concerns about any safety to the community. I don't think flight is an issue at all.
Strange, you say the complainant is here. You have you guys.
She said she can't hear.
Thank you.
Judge have it.
Man, they could have held the exam, but no. Man.
Do I have a yes report on this case? Yes. I mean, on my turn, on.
We're gonna waive if I can get the form.
All right.
Thank you, Your Honor. Marks.
Martin.
Thank you.
Okay, we're back on the record on People versus Lester John Mosley. Okay, after sidebar discussion, the court is going to refer this matter to pretrial services for final recommendation. In the meantime, as far as the exam goes, the court finds good cause for the adjournment. I will adjourn the matter to pursue responsibility. The tricky thing here is that there's a co-defendant who's going to be represented by an attorney. I need to make sure that that attorney is agreeable with whatever date we set so we can do this exam at one time. So what I'm proposing is I can take this matter over to tomorrow at 8:30. I can have both parties here and we can set the exam on an agreeable date. It'll be via Zoom. It'll be via Zoom. Yes.
We would want to in person.
No, I'm talking about the PCC, where we'll set an exam.
Okay.
I need both parties here, though. I need the other party here so we can see what their calendar is like.
And the preliminary exam, determine that the other attorney.
Yeah, so we can set up all at one time. So I will adjourn this to a PCC set for tomorrow. Please be on time, because I have to have my own matter at Frank Nursery tomorrow.
What time?
8:30, please.
May I approach it? If you get the same.
Thanks very much. Rick.
No, sir.
Thank you. Bye. We continue now. Mr. Strong.
Yes, Your Honor.
Not Mr. Strong, Mr. Johnson.
Yes, Your Honor, we're ready. We're ready.
Calling case 2456589, Rico State of Michigan versus Deon Marsh. Defendant is charged in count 1 criminal sexual conduct, second degree. Defendant has a habitual offender for defense notice. Appearances for the record.
Good morning, Your Honor. Cindy Woods, 86485.
Mackenzie Wheeler for the people, P86308.
And good morning, Your Honor. For the record, Jerry Johnson, P70773 on behalf of Mr. Martin is present, stands to my right.
Tell me your name for the record, sir.
Yes, Lord.
There's a date time set for preliminary examination, Mr. Johnson.
Thank you, Your Honor. Your Honor, I've had an opportunity to speak to my client in regards to his rights for a preliminary examination. My client is going to waive those rights to the preliminary examination with the understanding that the matter will be bound over to circuit court for further proceedings. Further, my client understands that with the preliminary examination, it is merely to show that a crime has been committed and probable cause exists that he may have committed that crime. My client understands that. He also understands that in my conversation with him, that once this is bound over, he will waive that right to a preliminary exam. Is that correct, Mr. Martin? Yes, sir.
Mr. Martin, please raise your right hand, sir. You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. You understand you have a statutory right to have a preliminary examination. By waiving the same, it means you won't have one. You'll be bound over to Wayne County Third Circuit Court as you stand charged.
Yes, sir.
You understand the nature and the purpose of the preliminary examination?
Yes, sir.
You understand if you never have one, the prosecution will have to establish a crime the charge was committed in the city of Detroit, probably cause of the committed.
Yes, sir.
Is anyone forcing you to waive your right?
No, Your Honor.
Is anyone promising you?
No, Your Honor.
Are you waiving your right freely, voluntarily?
Yes, sir.
Any objection from the people?
None, Judge.
Court finds defendant's waiver was made only involuntarily, given the court will therefore bind the defendant over to Wayne County Third Circuit Court. Criminal division of proceedings. His arraignment on the information date time will be May 6, 2024, 9:05 a.m. Bond will be continued.
Thank you, Your Honor.
Thank you, Mr. Johnson. Appreciate your patience, sir.
Thank you again.
Thank you, Judge.
Okay, now, Mr. Strong. Charmaine Latanya Hines. Calling case 2456756, State of Michigan versus Charmaine Latanya Hines. Defendant is charged with count 1 assault with a dangerous weapon, count 2 domestic violence, second defense notice, count 3 malicious destruction of personal property less than $200. Answers for the record.
Good morning, Your Honor. Shelley Drake for the people, P number 60249.
Good morning, Your Honor. Ryan Strong, appearing on behalf of the Township.
Charmaine Latanya Hines.
There's the date and time set for preliminary examination.
Your Honor, this is a situation where we do not have all of the video. It was a green light video. And we requested it. We have received it. The officer in charge had done a little bit. So this matter is going to have to be adjourned.
Yes, so, Your Honor, when we had the PCC last week, council did request that. Right away, I emailed the officer in charge and asked him. He had to look for it, but yes, I do have it, but I have trouble downloading. There's a lot of different names for it, for the video. So he was trying to do it, I did say in contact. Nothing done it, and he did email me yesterday, and said I still have not been able to get this done. And so I'm not going to let her examine. I don't have that, and I can address it.
When will it be done, you know?
He said he would try to get it done this week.
All right, I can put this over then to May 6th at 10:45.
At 35, you're at
10:45.
not a permission to address one of the high conditions that are related to conscious.
Go ahead.
Don's currently said $1,000 personal fines, GPS cover for hours of 9 a.m. to 6, 9 p.m. to 6 p.m. She's asking that she cover be removed for family reasons so she can not get the
My youngest child is graduating from high school and her events are coming up and her graduation is practice that there's no way I would make it back home. She also has prom coming up. I was saying my daughter has, my youngest child is graduating from high school. She has prom coming up as well. Thurston High School.
Thurston and Bradford?
Yes. And graduation is starting 7th, and so y'all have to be.
When is graduation?
Graduation is June 5th, and our prom is May 24th.
Judge, this scientist has not had any contact with the planning since.
You're not going to the prom, are you?
No, but I'm gonna send her off.
At your house, right?
Not at my house, actually, actually it's not at my house, it's at an Airbnb, and then we're gonna follow them to the actual venue.
Your I am not objecting to, we're changing the restrictions.
That's in the mic so she can hear you. We're getting a lot of background noise from some.
I'm not objecting to the report, amending the bond restriction to allow her to be able to do what she needs to do for her child's graduation and I have not received any indications that there have been any issues as to contact with the community.
But I don't believe the scientist is a flight risk. 51 years of age. She's currently employed. She has a master's degree in mathematics. No, a bachelor's or something. Bachelor's.
Where? Mary Grove College.
In mathematics, she has one minor daughter. Her lifestyle is very stable. There's no substance, no drug abuse, no health issues. She indicated to me she had one prior DV, and it was a misdemeanor. All of the said by her.
Mr. Drain, have any objections to me moving this other altogether? Send me an order to that effect. Ma'am, one slip up. Graduation and prom is gonna be the least of your worries about missing. Understand?
I understand, Your Honor, thank you.
Judge, so it's long water or
Something like something for phone.
No contact means no contact.
I understand. That's Mr. Cohen called, looking from last case. So he's been doing everything. He's probably gonna be a little late.
Good morning, Judge.
Hey, Ms. Mandarino, what can I do for you?
Before the morning got away from us, I need on Mr. Dante Smith's files, I need a maintenance order that accompanies that finding of competency.
Need a maintenance order, what is that?
That means he gets to stay at the forensic center and they continue to treat him rather than shipping him back to the Wayne County Jail, which gets him.
That sounds like a good idea. I like that idea.
Yeah, so I called the forensic center to set up a Zoom conference with him, and they're the ones who told me that, yes, without that that maintenance order, he gets shipped back and then, we're back in 2 weeks.
We've done something like that before. So I've never done one of those before.
That just, it's with the order that goes to the forensic center, finding him competent, it just includes
so
an order that
notations that the defendant is to remain there for treatment. I think it has something in that form. It's supposed to. Okay, we'll take care of it.
Okay, all right, perfect. Thank you. Appreciate it.
Right.
See you soon.
Okay. How you doing? Right. Trying to figure out what his background was.
With who?
I look at you.
But.
No sugar.
Text Ms. Triplett to see if she can send text for the rest of the week.
I did.
Is that the mic making all that noise?
I don't know what that is.
This is not gravelly out of nowhere.
What it is driving me crazy.
Yeah, that's it. No.
Is
It's
it
like
on
crumbling
now?
up the paper in the microphone.
All right. I guess it was coming from my microphone. Turn my microphone off and all of a sudden it's okay. So I'll just talk louder for you.
Okay,
That works.
Me, not you.
Thanks for putting all this on my face. Gestures.
Okay, I think we got it under control now. You ready, Ms. Franklin? Come on.
I'm
sir.
waiting to see. I'm waiting to talk to my computer.
Oh,
I've been
okay.
here since 11,
All right.
a little bit before 11, actually.
I don't know how I got this file down there. All right.
Take it with language.
Pronounce your first name for me, sir. Array. Calling case 24-56586 before the state of Michigan versus Array Divine Green. Defendant is charged in count 1 unlawful imprisonment, count 2 assault with a dangerous weapon, count 3 and 4 felony firearm, count 5 domestic violence. Appearances for the record, please.
Good morning, Your Honor. Shelley Drain for the people, P number 60249.
And good morning, Your Honor. Attorney Kiana Frank with P73015 on behalf of Mr. Otter Green, standing to my immediate left. Mr. Green, please state your name for the record. Array, I'm sorry.
Am I projecting okay, Madam Clerk Reporter? Can you hear me okay? All right. There's the date and time set for preliminary examination. Are people ready to proceed?
I'm not able to proceed at this time, Your Honor. The complaining witness is not present.
Your Honor, at this time we move to dismiss and to dismiss this matter.
So ordered. The court will dismiss this matter without prejudice.
Thank you, Your Honor.
Thank you.
If you got to go right down.
Yeah, I'll let you go.
Up to that.
I mean, no, go ahead, fill that out.
Oh, okay. Thanks.
Just like that, we're back on track. For a short time, anyway. So how long are you gonna be in the cast?
It's the food. I can take it off, but I have to have an MRI now. So it was gonna be at least 6 to 8 weeks. It might be a little longer because they say it can take nerves months
What the heck
to
are you
heal.
doing, damn? Slam dunk it again?
Well, no, I was keeping that foot on their necks. No, bro.
Roller skating?
No, the most basic of things, right? Y'all ready for this? Over the age of 40, roughhousing at home with my kids and my husband. And my daughter, no, my daughter power charged into my husband and he tipped back like this. His heel came back on my foot. I was right, it was freak I was like right already back up against the bed, so I couldn't move anywhere. And he's like 6'2", 200 plus pounds, and the heel of his foot came down right on top.
Y'all gotta try some other activities like football or something. Something safe.
Some safer, look, there's nothing safe with my 6-year-old, I swear. And she is starting football. She went in right up the gut like this.
Sounds like her mom.
Exactly.
Make that line straight. Judge? What do you think that line is drafted?
I think good. You know, they're addressing their concerns. You know, so I like it.
Anybody from all that?
Oh, yeah. Oh, yeah.
That's the one
Okay.
Attorney Sal's not here for the,
Shame on Mr. South.
like it.
Seems like a little bit.
But I don't remember walking. But we got to. You would have had an April 29th.
I was just calling you, Mr. South. I should have known you was walking right.
Right, you're too pretty.
Oh, now you don't need to.
Trying to take my elbow. I'm telling, Your Honor, he's trying to take my elbow out now. I did not do that.
She's kind of clumsy, be careful.
I am, I really am. I really am.
We don't want to get sued.
Nah, I'm not litigious in that respect. I can be litigious.
Where's Mr. Salad going?
Talk to his client.
Oh.
There's a translator, no translator sign.
Huh?
No translator sign. Or never.
No, she has not. I need my copy. You already know my paralegal sits and watches you on YouTube.
Who the?
My paralegal.
Really?
Yeah.
What's her name?
Tiffany.
Tiffany what?
Kelly.
Hi, Tiffany Kelly.
She said you watch it.
Tarrio.
For what time?
What you need?
I'm just waiting on my copy of it, just nothing like the. I didn't see it.
Which color do you get?
whichever one they gave me, I think I should get one of the yellows, I think.
Yeah, yellow.
I think the white stays with the court. I get a yellow and Shelley, you get pink, please? Yeah,
She get the
Shelley,
white or she get the white one.
I think we get the white.
the court gets the
She
original.
gotta make a copy of it. She didn't make a copy. Yeah.
Huh? You just trying to be different.
No,
You trying to ask
she gotta
the
make a
court
copy.
keeps the white copy. Shelley
It's 4
gets-
copies total.
Defense, defendant,
Let me make one. You make your copy.
prosecutor, and court, 4. No, I make copy on all these copies.
Don't worry. That's why you don't get no copy.
Well, you bang my elbows, I gotta pay.
Let's see. Oh. That's sealed.
Oh, okay.
That way just that way just further contact.
No, it's from, oh, that's my son. Yeah, look at that phone. One, go help my leg. Look back on. I don't think it's really what it's like from our end. Sure, stay on.
Sure.
Still don't have an interpreter?
What's up?
Oh, it's just texting. We don't have an interpreter for it, so that's.
But I have. My new way. There's no air. Right.
All right, Sugarfoot.
I know it's her game. Got my cape on and everything.
They said they can get something.
Mr. Salmon.
That's right.
So we have an interpreter problem. They said they can't get us one here for about an hour. Shaking their head, no, I said it's exact.
Your Honor, I don't know if you would allow it, but I do have a family member who, is bilingual who could interpret.
Interpreter for who?
The victims.
Does the defendant need an interpreter?
Defendant does not.
I don't think that's allowed, has to be certified.
I agree, Judge, especially since this is. We went to a waiver. Right.
And if it is, it's relative, I just wanted to know.
I appreciate it. We need a certified interpreter. So. What are you looking like Wednesday, Mr. Salmon?
Which day, Judge?
Wednesday?
Okay, Judge.
No time Wednesday?
Afternoon.
Afternoon is the Tigers game. I wouldn't.
I know.
I wouldn't do that today. How
Your
about
Honor, I
Friday?
would be available at noon.
I'm sorry.
I would be available at noon. Same
The
time as
Tigers
today.
game, Judge.
What about Friday?
I'll make Friday work, Judge.
I would
What
be
time is good
available.
for you? I'm wide open Friday.
I'm not available in the morning in the hearings and framework. I'm available Monday of next week.
What time are your hearings?
My hearings are in the morning.
What time?
I have sentencing, well, starting at 9, I have motions, argue motions at 10. And that's all of the defense counsels are. That frankly. Yes, sir.
I have one case on my docket Friday at 10 o'clock. I hate to set this at 1. The only case is at 10.
I could do. Or Monday, available all day Monday.
You available Monday, Mr. Salmon?
I can move my Monday minutes around.
Is your client in custody or out?
It's out of custody.
Okay, good. Let's do Monday then at 10:45.
10:45, Your Honor.
Yeah, let me call the case.
I want to address those provisions of the file.
Where's Mr. Tellez? He's there. Calling case 2456499, for state of Michigan versus Mario Deon Tellez. Defendant is charged with count 1, torture, count 2, assault or assault battery, count 3, domestic violence. Appearances for the record, please.
Good afternoon, Your Honor. Diana Lynch on behalf of the people, P84589.
May it please the Senate Court, Alvin Salmon, P23717. Tellez, please identify yourself for the record.
Mario Deon Hover.
So today's the date and time set for preliminary examination. We have a little bit of an issue with the interpreter. I understand that the complaining witnesses need interpreter. We don't have one present at the moment. We can't get one before an hour. So I think we're gonna have to put this matter over. And then looking at next Monday, May 6th at 10:45.
Thank you, Your Honor, that works for the people.
So that's great.
That's fine, Judge.
All right.
10:45 makes.
Court finds good cause for the adjournment. Final be considered. Oh, you said you wanted to address something?
Yes, Your Honor. There is a GPS tether forbidding my client from moving back to his home. Now, this is his home. Actually, it's owned by his brother, President Court. My client's lived there for 7 years. The complainants in this matter, who are adults, came up there unannounced. And have other, no one's living in that house right now. We understand that. As such, Your Honor, we're worried about vandalism.
Nobody's staying there. Is there an issue with him going back there?
Your Honor, there's not. I do want to put on the record that, the defendant was made aware that it was his children arrived from California, and he made arrangements.
I don't care about that. We're talking about something altogether different.
The house is fine. The other item, Your Honor, that I'd like to put on the record is that, the defendant's sister, presumably who lives in California, called the family who lives in Mexico. The recording is in Spanish. It's over 19 minutes long. And part it addresses the defendant's friends wanting to have the address of where the witnesses are living. It is, according to my understanding, from the cousin who is bilingual, that there are threats and demands where the aunt is wanting the address of the witnesses. She provides that the address is wanted for the friends of the defendant. And I shared this information with the defense counsel. I will be sharing the recording with the IOC so it can be placed into evidence.com. I just received it last night around 9 o'clock at night.
Judge, obviously, I have not heard, I didn't need a translation of what may said. Accordingly, will be very glad to see whether that matches.
Mr. Tellez, you understand the seriousness of this case, don't you?
Yes.
Have you spent any time in the Wayne County Jail, sir?
No,
Do you want to?
I don't want to.
You know, that's what's gonna happen if this kind of stuff pans out to be true. Whoever's calling on your behalf are not doing you any favors whatsoever. You understand that? I would suggest to you, and I'm not saying anybody did anything inappropriate, because I don't know, I haven't heard a thing. But it doesn't look good. It doesn't sound good. And if you force my hand, I'm gonna do what I have to do. If that means putting you in jail and going after your sister or whoever it is, I'll do that. You understand? You might want to relay that message to them to stop all this foolishness. No calling for any reason whatsoever. Got it? Okay. Bond continue.
Thank you, Judge.
Okay, so- Oh, as it relates to the home,
Yes, Your Honor.
have you verified nobody's there?
I have verified. I do know that for a fact.
Okay, send me an order that he can return back to his home.
Thank you, Judge. I'll do that. Just brief. Thank you.
No, Mr. Cohen yet?
Yeah, he just came in.
Oh, there you go.
And I just talked to him, so he's gonna talk to everybody.
Okay. What we doing, Mr. Cohen?
We're gonna waive, Judge.
Okay.
It's gonna be a limited window based on who's here. Thank you. I can get a waiver. Sam, right?
Yes, sir.
Thank you. Where's the waiver?
This is not.
Deon Hover. Calling case 24-56731, people of the state of Michigan versus Deon Hover. Defendants charged in count 1, assault with intent to do great bodily harm, less than murder or by strangulation. Count 2, assault with a dangerous weapon. Count 3, assaulting, resisting, obstructing police officer. Count 4, aggravated domestic violence. Appearances for the record.
Good afternoon, Your Honor. Shelley Drew for the people, P number 60249.
Good afternoon, Your Honor. Neighborhood Defender Service by Jonathan Cohen, P86151, appearing in person on behalf of Mr. Deon Hover, who appears to my left out of custody. Mr. Hover, please state your name.
Deon Hover. Today's the time set for preliminary examination, Mr. Cohen.
Yes, Your Honor. At this time, we are willing to enter a waiver of Mr. Hover's right to have a preliminary examination. And this is based on, well, that being Mr. Hover's desire, as well as the people informing the defense that they intend to dismiss counts 1, 2, and 4, and only count 3, resisting and obstructing an officer will be bound over.
All right. Sir, please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Thank you, sir. You understand you have a statutory right to have a preliminary examination. By waiving the same, that means you won't have one. You'll be bound over on count 3 of the complaint warrant as assault and resisting obstructing the police officer. You understand the nature and the purpose of the preliminary examination? Yes. You understand if you were to have one, the prosecution would have to establish that count 3 was committed in the city of Detroit, that there's probable cause to believe you committed it. Is anyone forcing you to waive your right? Who's forcing you to waive your right? No. Okay, you gotta listen to me now. Let's try it again. Is anyone forcing you to waive your right? No. Has anyone promised you anything? No. Are you waiving your right freely and voluntarily? Yes. Any objection from the people?
No objection.
The court finds defendant's waiver is made knowingly and voluntarily, or therefore bind the defendant over on count 3, assaulting, resisting, obstructing police officer. Pursuant to the people's motion, you are moving to dismiss counts 1, 2, and 4, Ms. Graham?
Yes, Judge.
Court will dismiss counts 1, 2, and 4. The defendant will be bound over to Wayne County Third Circuit Court Criminal Division for further proceedings. His arraignment on the information date and time will be May 13th, 2024 at 9:00 a.m. Bond will be continued.
May we address that briefly, Your Honor?
Okay.
So we are asking specifically with respect to the GPS tether that Mr. Hover is currently on. We're asking the court to consider removing that at this time, given dismissal of the underlying domestic charges. The court already was gracious enough at the PCC to reduce Mr. Hover's bond from a $75,000 cash bond to a smaller percentage bond, which he was able to post. He does have his GED, he has close family ties. I don't believe he has a history of missing quarter being a flight risk. And he has been employed at Family Dollar since February of 2024. Do you still have that job, Mr. Hover? So that would, it sounds as if his employment, which was close to the home that he did share with the complainant, original complainant in this case, Breonna Galloway, was perhaps within the exclusion zone. It's a Family Dollar. So for that reason, we're asking to remove it.
Mr.
Your Honor, I am not objecting to that request. Number one, it was one count, also I've received
All right. Give me a proposed order to remove. 7.
I will do so, Your Honor.
Okay.
And we do have a proposed order dismissing counts 1, 2, and 4 for the court as well.
Okay.
May I approach the clerk with that?
Yes.
May I ask if I were to forward an email proposed order to the court and the people with respect to removal of the tether, would the court's normal course of action be to, once signed, send that directly to the tether unit?
Yes.
Very good. Thank you, Your Honor. I will send that over today.
All right.
Thank you.
Well, folks, that concludes the docket for today. Hope to see you hope to see you tomorrow, same bad station, same bad time. Thank you, you too now. Bye.
Bye. Judge King, bar results will be this week, so prayers, please. Thank you.
Absolutely, you got this.
so.
See you.
Bye, Jennifer. Good to see you.